Hello, welcome to today's episode of Legally Raven Haired. Okay, it's coming up on a year. I got to pick a name. But anyway, thank you so much for joining us today. Once again, this video is sponsored by Bar Exam Drills. Bar Exam Drills is a great website that is helping me get my law degree not my law degree, but helping me pass the bar exam without going to law school, trying to keep it debt free. Whoop, whoop. Okay, anyway, let's get into the video. Federal Rules of Civil Procedure, Rule 12. This is talking about defenses and objections when and how presented, motion for judgment on the pleadings, consolidating motions, waiving defenses, and pretrial hearings. So it's about a lot. So let's read it together. So Rule 12A, time to serve a responsive pleading in general, unless another time is specified by this rule or a federal statute, the time for serving a responsive pleading is as follows. A, defendant must serve an answer within 21 days after being served with the summons or complaint, or 2, if it has been timely waived, service under Rule 4D within 60 days after the request for waiver was sent, or within 90 days after it was sent to the defendant outside any judicial district of the United States. So the defendant must serve an answer within 21 days after being served with the summons or complaint, or if it was timely waived, service under Rule 4D within 60 days after the request for waiver was sent, or within 90 days if they're out of the United States. Let's just go look at Rule 4D really quick and come back. All right, let's go down to Rule 4D, waiving service. Requesting a waiver, an individual, corporation, or association that is subject to service under Rule 4E, F, and H has a duty to avoid unnecessary expenses in serving the summons. The plaintiff may notify such a defendant that an action has been commenced and request that the defendant waive service of summons. The notice and request must be in writing and be addressed to the individual defendant or for the defendant subject to the service Rule 4H to an officer, a managing or general agent, or any other agent authorized by appointment or by law to receive service of process. So that is what happens, waiving service. So the hope is to save money. All right, so let's go back here. It says B, a party must serve an answer to a counterclaim or a cross-claim within 21 days after being served with the pleading that states the counterclaim or cross-claim. What is the difference between a counterclaim and a cross-claim? Let's look it up. What is the difference between a counterclaim and a cross-claim? Looks like I'm not the first one who asked this question. All right, so let's look at here. A counterclaim, okay. All right, so we're gonna Green Mistera Law Attorneys at Law 919. I think that's North Carolina. So let's see. What's the difference between a counterclaim and cross-claims? An overview. If you've ever been served in a civil lawsuit, you are now the defendant in a case. You have to answer the complaint, but did you know that you have more options than simply defending yourself? You also have the option to bring a counterclaim or a cross-claim against the plaintiff or other defendants. This is essentially a way of turning the tables on the plaintiff, the person filing the complaint, alleging that they are actually the ones at fault and forcing them to respond and mount a defense. When these claims, while these terms may sound like legalese, they're practical tools, valuable arrows in your quiver should you find yourself or your business embroiled in litigation. Here, we provide a high-level primer for each type of claim, what they are, what purposes they serve, and how you and your litigation attorney might choose one offensively in a lawsuit. So let's be offensive. What is a counterclaim? Think of a counterclaim as saying, actually, plaintiff, you are the one in fault, sometimes called a countersuit or a counterclaim. All right, so that is what a counterclaim is. What is a cross-claim? The main difference between a counterclaim and a cross-claim is who is countersued. A counterclaim is brought by a defendant against the opposite party, the plaintiff. A cross-claim is a claim by either a plaintiff against another plaintiff or a defendant against another defendant. Simply put, it is a claim brought against someone on the same side of the aisle on a case. Let's get an example. Let's take the same example. When plaintiff sues defendant for non-payment, imagine defendant brings her ex-spouse as a co-defendant, claiming that he is the one who initially agreed to pay the contractor for renovations. This is her way of saying, I'm not liable for the breach, he is. Okay, so the plaintiff sues the defendant for non-payment. The defendant brings her ex-spouse as a co-defendant, claiming he is the one who initially agreed to pay the contractor for renovations. Okay, so what counterclaims and cross-claims are not? Neither a counterclaim or a cross-claim is a substitute for providing an answer to a complaint. If you are served a complaint, you generally must file an answer to the complaint, whether or not you intend to bring a counter or cross-claim. The answer is the defendant's response to the plaintiff's original suit, while the counterclaim and cross-claim are the defendant's additional allegations and claims against the plaintiff or co-defendant as applicable. So a counterclaim is saying, no plaintiff, you're in fault. It's across the aisle. The defendant comes back to the plaintiff and says, your fault. A cross-claim is somebody saying, no, it's on the same side of the aisle. So it's like, no, this other defendant or this other plaintiff has liability in this lawsuit. So now we know the difference between the two. All right, so sorry for digressing here. Let's go back to Rule 12, but we need to look up things we don't understand, just like when we were kids and we looked up things in the dictionary. Okay, so C, a party must serve a reply to an answer within 21 days after being served with an order to reply, unless the order specifies a different time. 2, United States and its agencies, officers, or employees sued in an official capacity. The United States, a United States agency, or United States officer or employee sued only in an official capacity must serve an answer to a complaint, counterclaim, or cross-claim within 60 days after service on the U.S. attorney. United States officers or employees sued in an individual capacity. A United States officer or employee sued in an individual capacity for an act or omission occurring in connection with duties performed on the United States behalf must serve an answer to a complaint, counterclaim, or cross-claim within 60 days after service on the officer or employee or service on the United States attorney, whichever is later. So let's read that again. Within 60 days after service on the officer or employee or service on the United States attorney, whichever is later. So whichever is later of the service on the officer, the employee, or the service on the United States attorney is when it's due. Okay, whichever the latest one is, 60 days after that. So effect of a motion. Unless the court sets a different time, serving a motion under this rule alters these periods as follows. If the court denies the motion or postpones its disposition until trial, the responsive pleading must be served within 14 days after notice of the court's action. Or B, if the court grants a motion for a more definitive statement, the responsive pleading must be served within 14 days after the more definite statement is served. How to present defenses. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required. But a party may assert the following defenses by a motion. 1, lack of subject matter jurisdiction. 2, lack of personal jurisdiction. 3, improper venue. 4, insufficient process. 5, insufficient service of process. 6, failure to state a claim upon which relief can be granted. And 7, failure to join a party under Rule 19. I don't know what that means. Look for the next video. A motion asserting any of these defenses must be made before pleading. If a responsive pleading is allowed, if a pleading sets out a claim for relief that does not require a responsive pleading, an opposing party may assert at trial any defense to that claim. No defense or objection is waived by joining it with one or more other defenses or objections in a responsive pleading or in a motion. C, motion for judgment on the pleadings. After the pleadings are closed, but early enough not to delay trial, a party may move for judgments on the pleadings. Result. D, result of presenting matters outside the pleadings. If on a motion under Rule 12b-6, so 12b-6, failure to state a claim upon which relief can be granted, or 12c, motion for judgment on the pleadings, matters outside of the pleadings are presented to and not excluded by the court, the motion must be treated as one for summary judgment under Rule 56. All parties must be given a reasonable opportunity to present all the material that is pertinent to the motion. Motion for a more definite statement. A party may move for a more definite statement of a pleading to which a responsive pleading is allowed, but which is so vague or ambiguous that the party cannot reasonably prepare a response. The motion must be made before filing a responsive pleading and must point out the defects complained of and the details desired. If the court orders a more definite statement and the order is not obeyed within 14 days after notice of the order or within the time the court sets, the court may strike the pleading or issue any other appropriate order. Motion to strike. The court may strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. The court may, 1, on its own, or 2, on motion made by a party either before a pleading or on motion made by a party either before responding to the pleading or if a response is not allowed within 21 days after being served with the pleading. Joining motions, right to join. A motion under this rule may be joined with any other motion allowed by this rule. 2, limitations on further motions, except as provided by Rule 12H or 3, a party may make a motion under this rule, must not make another motion under this rule, raising a defense or objection that was available to the party but omitted from its earlier motion. Okay, so now let's see what H says. Waiving and preserving certain defenses. When some are waived, a party waives any defense listed in Rule 12B 2 through 5 by A, omitting it from the motion in the circumstances described in Rule 12G 2, or B, failing to either make it by motion under this rule or include it in a responsive pleading or an amendment allowed by Rule 15A1 as a matter of course. 2, when to raise others. Failure to state a claim upon which relief can be granted to join a person required by Rule 19B or to state a legal defense to a claim may be raised in any pleading allowed or order under Rule 7A by a motion under Rule 12C or C at trial. Lack of subject matter jurisdiction. If the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. I, hearing before trial. If a party so moves any defense listed in Rule 12B 1 through 7, whether made in a pleading or by motion, and a motion under Rule 12C must be heard and decided before trial unless the court orders a deferral until trial. All right, so here we have Rule 12, defenses and objections, when and how presented, motion for judgment on the pleadings, consolidated motions, waiving defenses, pre-trial hearing. Thank you so much for turning into this episode of Legally Narette, Legally Raven-haired. This is Devaney Wilmot, and this video is sponsored by the Marchica Law Firm in Vermont. That is my supervising attorney, helping me through this process of learning the law without going to law school, and bar exam drills, which is helping me to prepare for the bar exam. It's so true. People say that law school teaches you one thing, studying for the bar teaches you another, and practicing law is a third. This process is allowing me to learn the law, to learn the bar exam, and to learn the practice of law. Thank you so much. Signing off. Bye-bye.